Hey, y'all, and welcome to tonight's live stream. Well, Alex Murdaugh has called for the briefcase. He's asked the agent to come over. He's scanned his retina. He's used his fingerprint. He's opened the briefcase and he has hit the red button. Alex Murdaugh has declared war on Judge Newman. We are going to talk about that tonight, about what that means and what it means for his motion for new trial. We are back on the Murdaugh case tonight, the case that absolutely seems to be unable to stop. I hope you are looking forward to a great weekend. We have finally made it. I hope you have something really fun planned. I'm going to be going to Arts and Crafts Festival this weekend with some friends, and I can't wait for that. So, as I said, Team Murdaugh has gone for the nuclear option. They have actually asked to have Judge Newman removed from the case. But they didn't ask Judge Newman to remove himself from the case. Instead, they asked the South Carolina Supreme Court to remove them from the case. So this is, in lawyer world, this is declaring nuclear war. This is a very, very serious request. So what we're going to talk about tonight is I'm going to start with talking about what's going on. We're going to specifically look at the motion that the Murdaugh team has filed. We're going to read through some pieces of it, and I'll talk to you about that. Then we're going to talk about why it's so significant and why I consider in any way the nuclear option, why it's something that really, really is a big deal in the legal world. And then third, we're going to talk about what happens next. What are the things that are going to be, what are the consequences for the case? What are the consequences for Murdaugh's new trial? Now, let me tell you about what's coming next, because on Monday, the state has filed its response to Alex Murdaugh's motion for new trial. And we are going to do a deep dive into that. You want to hear what Becky Hill has to say, the clerk of court? What does Becky Hill say, after all, about all of the allegations against her? We're going to take a look at her affidavit. We may have to break that piece out separately, but we're going to look at the state's motion. It's packed with facts and information. It's a really, really well-written motion. We're going to cover that, and you do not want to miss that. So be sure to hit the subscribe button. That'll be Monday. And then we'll also be covering, absolutely, we are definitely getting back to the Delphi murders case as well. I saw some people asking about that in the chat before we got started. So be sure to subscribe. And if you would hit the like button, it'll really help the video get out. And I would appreciate that. So first of all, I want to talk about what is it exactly that the Murdaugh team has filed. And it has a really bizarre name. I'm going to show it to you, add it to the stage here. It's called a petition for a writ of prohibition. Wow, sounds like they're asking to go back to no liquor, doesn't it? For those of you who are Americans, prohibition was a period of time when there were no alcohol sales allowed in the United States. So that's what it sounds like. But let me tell you what it means. It's petition for request to, and they filed it in the South Carolina Supreme Court, request to the South Carolina Supreme Court for a writ of prohibition, which is an order from a higher court to a lower court saying you can't do this. So they want the South Carolina Supreme Court to tell Judge Newman that he has to stop acting in not just the motion for new trial, not just the murder cases. They want the Supreme Court to say he can't act in any Murdaugh case. Remember, there is a trial coming up in November. The trial is coming up. Let me bring this out so I can talk to you a little bit better. So there's a trial coming up, and that trial relates to some of the financial crimes. Well, to one set of financial crimes, and there are some other trials scheduled for that. Judge Newman is the judge on that as well. What's super interesting about that is Judge Newman is scheduled to go ahead and take retirement in January, but this trial would happen in November before he retires. And so the motion is saying, the petition is saying, we want him off every case. We want him off everything. So we'll take a look at what that is. But not just about the motion for new trial. We knew there would be an argument about that because, as we talked about in that very first press conference announcing the request for new trial and stating that some of the jurors had been approached by the clerk of court, even in that, there was, from the beginning, there were statements from the Murdaugh team saying, well, Judge Newman is going to be a witness, so he won't be able to hear this case and things like that. So we knew that they would be asking for that, but they go further than that in this motion. So we will talk about that. There are two primary grounds that they have. The first is they say he's going to be a witness. That's the part we knew about. The part that they add to that is they say the statements he made after the verdict, the statements he made during sentencing, the statements he made to the jury as he was releasing them, the statements he made to the media afterwards, all of those things, they say, show he was biased and that he has to be taken off the case. Those were inappropriate comments, and we want him off the case. So let's go ahead and take a look at, I'll make this a little bit bigger so you can see it better, and we will take a look at some of what they said. I have to work with two screens here, so it'll take me just a second. Okay, so, and this is the part where that I was just telling you about, that they are not just asking that he be taken off the murder cases. They're asking that he be taken off future trials of, I think they mean, or indictments against him, or maybe they mean trials related to indictments against him. So let's go ahead and read this next part. Judge Newman has personal knowledge about the clerk of court's conduct, which will undoubtedly be disputed at an evidentiary hearing on the motion for a new trial. That's the part that where they say he's going to be a witness. Further, after the jury returned guilty verdicts, Judge Newman made numerous statements in violation of the Code of Judicial Conduct that require his disqualification from presiding over further proceedings in this matter. Now, think about it. When it comes to nuclear option stuff, stating that the judge is going to be a witness, that's lower key, right? You could even tell the judge, hey, judge, we think you have information. We think you're going to be a witness, and perhaps he would recuse himself. This is different. It's going further than that. Let's go back in. It says, requires his disqualification. These statements include congratulating the jury for returning the correct verdict, statements at sentencing evidencing personal bias, and statements in public interviews after the trial, including an interview on a nationally broadcast news program in which Judge Newman stated his personal opinions regarding Mr. Murdaugh's guilt, legal issues on appeal, and strategic choices by Mr. Murdaugh's counsel during trial. Now, I would say that probably particularly bothered the attorneys for Murdaugh, because it seemed to be they were commenting directly on him and on what it's on them and on how they had performed. So I put this next part in yellow. It's not technically all that related to explaining this motion to you, but I just thought you would really be amazed by this. Mr. Murdaugh, this is in the defense brief. This is Murdaugh's team describing Alex Murdaugh, okay? Mr. Murdaugh is a disgraced former attorney and drug addict. Once a prominent member of the bar, Mr. Murdaugh is charged with stealing millions from his clients and others who trusted him, and he gave millions to violent drug dealers who fed his voracious opioid addiction. His law firm confronted him about his thievery on September 3rd, 2021. He resigned from the firm and, after a failed suicide attempt, assisted by his drug dealer, entered drug rehabilitation. He was arrested immediately upon leaving a rehabilitation facility and has been incarcerated ever since. I just couldn't help but think, dang, these are the people who are on his side. This is the most positive thing that someone could say about him. Is right there. Wow. Anyway, I thought y'all would be interested in that description by the defense team of Alex Murdaugh. But notice what they're carefully doing. They're carefully saying, this is, oh, I didn't even have, I was reading it to you, but not showing it to you. Let's go ahead and add it back to the stage. Okay. So what they're saying to him is this was related to drugs. This was related to finances. They are distinguishing that from the murder. They continue to maintain that he did not commit the murders of his wife and his son. Okay, we'll keep zipping through here. All right, number 4. And so I skip a lot when it's either just too technical or legal, and I don't think it can kind of be explained or isn't necessary. Sometimes people add a lot of stuff that isn't necessary. So I wanted you to think this is going to tell you what the standard is. In other words, when and why would the court grant this? The writ will be granted only to prevent an encroachment, excess, usurpation, or improper assumption of jurisdiction on the part of an inferior court or tribunal, or to prevent some great outrage upon the settled principles of law and procedure. Now think about how serious. Great outrage upon the settled principles of law and procedure. High standard. So this has to be something that is improper. Court shouldn't be having jurisdiction over this at all, or it's going to be a great outrage upon the settled principles of law and procedure. That's really a significant standard, very high standard. The court in which the original action, and if the court in which the original action is brought has jurisdiction and the usual remedies provided by law are adequate and complete, the writ should not issue. And I think my guess is that the state will look at things like that, will argue things like that in its response, and will say, look, this is not something that should start in the Supreme Court. The Supreme Court doesn't start by telling Judge Newman, you're off the case. Instead, you first go to Judge Newman and you say, we think you should get off the case for these reasons. Judge Newman decides yes or no, and then you take it up if Judge Newman doesn't do what you think he ought to do, which is get off the case. That's exactly what the Brooks-Houck court said when Brooks-Houck moved for the judge to be recused. And by the way, I recognize that I'm telling you that this is a nuclear option, and we have 3 cases where this is being done. 3 cases we're talking about, which is crazy. The Delphi murders, the Brooks-Houck case, and now the Alex Murdaugh case. So this is not a normal thing, and yet you can see it's happened in all 3 of these cases. I'll talk about that at the end when I talk more about the nuclear option side of this. So let's keep learning more about what they're saying. The Code of Judicial Conduct requires Judge Newman to disqualify himself from hearing Mr. Murdaugh's motion for a new trial. Judge Newman has personal knowledge about the clerk of court's alleged misconduct. Now, that's the part we were expecting. A judge shall disqualify himself or herself in a proceeding in which the judge's impartiality might reasonably be questioned, including but not limited to instances where the judge has personal knowledge of disputed evidentiary facts concerning the proceeding. The motion does not suggest that Judge Newman did anything improper during the trial as the presiding judge. However, Ms. Hill's actions make Judge Newman a material witness regarding her conduct. Ms. Hill told Judge about a Facebook post. We've talked all about this, and no such Facebook post was made. So at this point now, one of the things, so this is the first ground that he will be a witness, and a witness with personal knowledge. Newman, they're saying, did nothing wrong. So this ground in no way impugns Judge Newman, has anything to do with him. It's about Becky Hill having lied about a Facebook page. She's the clerk of court. Now, the state is going to say, look, why do they need the judge's testimony? We know what Becky Hill said. It's in a transcript. So we could just read the transcript. I mean, people lie in court and you don't call the judge in to testify. You just read the transcript back and then you say that was a lie. You don't need the judge to testify about that. So they are going to argue. Here is the argument that the Murdaugh team is going to make in response to that. Statements made by Judge Newman during an in-camera hearing involving Juror 785 indicate that Judge Newman and his law clerk had multiple conversations about Juror 785 with the clerk of court that are not reflected on the record. So they're trying to go ahead and answer that what's likely to be the state's argument. Judge Newman also stated on the record, I'm not too pleased about the clerk interrogating the juror as opposed to coming to me and bringing it to me. And that Becky Hill, she had indicated that she read a Facebook post over the weekend referencing this. This is Friday, and she just mentioned it today. In other words, it wasn't something that she necessarily put on the record. It was something that she mentioned to the judge. And I'm going to go ahead and make it a little bit bigger so you can read it a little bit better as we go through. Mr. Murdaugh raised this issue with Judge Newman via letter. The state responded with a letter asserting Judge Newman's knowledge of these facts is not critical or unobtainable by other means, and therefore he need not recuse himself. So one of the things that may have caused the Murdaugh team to go ahead and do this is they raised this issue in a letter and Judge Newman did not act. What they were afraid of, you can tell this from something they say later in the motion, is that, or petition, that he would go ahead and rule. That he would just rule, deny the new trial, and then that's all they get. Or even worse, because the state has suggested that all of the questioning of the jurors needs to happen, and this is a preview of Monday, but the state has said all of the interrogation of the jurors needs to be by the judge. No one else should be involved. So the attorneys shouldn't be involved. They shouldn't be allowed to ask questions, just the judge. So what the Murdaugh team is worried about is Judge Newman is maybe doing this as we speak, or has already done it, or will do it. They won't be involved. The judge will simply issue a ruling saying, okay, I talked to everybody and clearly the Murdaugh team was wrong and the state was right. And then they're stuck. You'll read about that later, but I think that's why they're going ahead and filing this with the Supreme Court. Let's keep reading. It could be the case that the information the judge possesses is readily obtainable from other sources, like the record or other people who were in court and heard all of this, but that would not change his knowledge of disputed evidentiary facts. For example, no one would question the need for a judge to recuse himself from presiding over the prosecution of a crime he personally witnessed, even if there were many other witnesses and the crime were caught on video, so that his testimony would be unnecessary. Here, Judge Newman has personal knowledge of Ms. Hill's representations to him about a Facebook post. Mr. Murdaugh alleges the first post never existed and that she knew the purported replacement post was not by the ex-husband of a juror. Ms. Hill presumably will not admit that. They are evidence regarding Ms. Hill's attempts to influence the jury's verdict. So this, now we're going to get into the second reason here, which is if the judge witnesses a crime, the judge can't preside over the case. So their arguments are that she said things to him off the record and that this is akin to a judge witnessing a crime happening, and in that case, he would be taken off. So that's their argument for why it is that even though Becky Hill's statements, many of them are on the transcript, there still needs to be, there still is the possibility Judge Newman himself will be a witness. So that's the argument that they're making. And that covers our first ground, that he's a witness and knows things, heard things off the record, and therefore has to be able to talk about that. So now the second ground is that there were inappropriate comments after the verdict. Let me make this a little bit bigger for me to be able to read to you. Just a second. So now they're going to argue that this is not just that Judge Newman is a witness. That's not the only issue. It's also what he said after the verdict. Those statements, they say, got him into trouble, ran afoul of the rules of judicial conduct. He was not, for example, supposed to commend jurors on what they did. He's made statements that show he is biased, he's unfair, and he's violated these various rules of judicial conduct. He's got to be taken off the case. So the first one that they're going to talk about, and we'll read a little bit more of this. Judge Newman's comments to the jury after the verdict was returned violated Canon 3 of the Code of Judicial Conduct. A judge shall not commend or criticize jurors for their verdict other than in a court order or opinion in a proceeding, but may express appreciation of jurors for their service to the judicial system and the community. So, okay, you've got this over here, and now you're going to compare. That's what the standard is. The judge should not commend or criticize jurors for their verdict other than in a court order or opinion. in a proceeding. Now, here's what he said. Here's what he said to the jurors as he was dismissing them. I will make no comment now as to the extent of the overwhelming nature of the evidence, but certainly the verdict that he's addressing the jury, that you have reached is supported by the evidence, circumstantial evidence, direct evidence, all of the evidence pointing to only one conclusion, and that's the conclusion that you all have reached. So I applaud you all for, as a group and as a unit and individually, evaluating the evidence and coming to a proper conclusion. So the question for the court, the question for you, and I'm going to ask you right now, if you would put in the comments, let me know your opinion. Do you believe that that was the judge commending or criticizing the jury for their verdict? Because that's what they're going to have to answer. Is that what you read right there going to be grounds? All right, let's keep going. Number 10, Judge Newman broke a binding rule of conduct to opine on the record that any errors discovered in the trial proceedings, whether on direct appeal or collateral review, should not result in a new trial. That shows bias against granting a new trial, even if warranted. So when it comes to the appeal, Murdaugh is going to argue that the financial crimes should not come in. That's one of the things he's going to argue. Murdaugh, here's what there's a little bit of technical in this, but what Murdaugh is saying is that the judge was trying to argue the appeal in advance. Like when Murdaugh said this was overwhelming evidence, he was using basically code language for lawyers, because if the evidence was overwhelming against Alex Murdaugh, then the fact that one error was made or some piece of evidence came in, the court will say, look, the evidence was overwhelming. This did not make a difference in the case. And so they're saying that Judge Newman was throwing in words like that because he was trying to get ahead of the appeal. He was trying to say to the appellate court, look, this was overwhelming. All this stuff about financial crimes, it was all overwhelming. That's what the Murdaugh team wants to argue. That's what they say he meant when Judge Newman made those statements. And that shows, they say, there's no way he's going to grant a new trial. That's impossible. He's biased against it. He will never do that. Okay, let's keep reading. So because that was the first part. At sentencing, what he said about the verdict. Now we're going to talk about what he said at sentencing itself. Sorry, not at sentencing. What he said to the jurors, inappropriate comments about the verdict. Then at sentencing, here we go. Judge Newman's statements at Mr. Murdaugh's sentencing show personal bias in violation of Canon 3 of the Code of Judicial Conduct, which says a judge shall perform judicial duties without bias or prejudice. Mr. Murdaugh denies murdering his family, but does not deny that the jury returned a guilty verdict and that it would be appropriate for the sentencing judge to comment with disapproval on the commission of such a horrible crime. So the statements at the sentencing, they're saying, just the fact that he said that, you aren't taking responsibility, things like that, those, the Murdaugh team says, show personal bias. Now, what's interesting about this argument is they are about to argue that he has bias, that the judge has bias against Murdaugh, not just related to this case, but in general. So let's keep reading. But Judge Newman's comments at sentencing show personal bias regarding Mr. Murdaugh and his family. Judge Newman's comments take personal offense that Mr. Murdaugh denied he committed the murders, which is Mr. Murdaugh's legal right. So they're saying, look, you did not believe Alex Murdaugh, and you were even offended that he defended himself. Therefore, you are biased against him in a way that's more than just you didn't buy it and you're going to sentence him. But I will say this. It is very common in sentencing for judges to say, you didn't take responsibility for this. And, you still aren't taking responsibility for that. I don't know how far they're going to get on that argument, but we'll keep reading because they take it a little bit further here. Here is another comment that was made from Judge Newman to Alex Murdaugh during sentencing. But amazingly, to have you come and testify that it was just another ordinary day, that my wife and son and I were out just enjoying life. Not credible, not believable. You can convince yourself about it, but obviously you have the inability to convince anyone else about that. So if you made any such arguments as a lawyer, you would lose every case like that. Now, here's what the Murdaugh team is saying. They're saying this is you, the judge, saying you find Alex Murdaugh not credible. That's you commenting on what you believe about the evidence, not you commenting on the jury has found you guilty. You have failed to take responsibility for what they found you guilty of, and therefore I'm going to sentence you to, etc. But instead, they're saying, this is the judge saying, I personally think that you're not credible. I personally believe that all of the evidence was overwhelming against you. And they're saying, the Murdaugh team is saying, that goes too far. And they're about to take it yet further. They take it further all the way through this. The outrage extending beyond Mr. Murdaugh's own conduct to the supposed conduct of Mr. Murdaugh's ancestors. And the Murdaugh team says, look, you can't blame somebody for, if you want to sentence somebody, if you want to blame somebody, you have to blame them for what they did. You can't blame them for what their dad did or their granddad. And but here, and they're going to take it further and talk about some more comments that he made at sentencing. Even during this trial, this is the judge talking during sentencing, the law enforcement has been maligned for the past 5 or 6 weeks by one who had access to the wheels of justice to be able to deflect the investigation. Now, that really offended the Murdaugh team because it suggests that what was done, what was argued, malignment of law enforcement, was really improper. And who argued that? The attorneys, not just Alex Murdaugh. The attorneys argued that. They say this was someone maligned them who had access to the wheels of justice to be able to deflect the investigation, which overall, there was not the argument that he did or managed to deflect the investigation. So this sort of seems to relate more to the presentation of the evidence at trial. So they got very upset about that, and they went ahead and, well, we'll read it. We'll talk about it. It refers to Mr. Murdaugh's family as a symbol of corruption in the Low Country, and specifically to his father, grandfather, and great-grandfather serving as a solicitor in the 14th Judicial Circuit for 86 years. Judge Newman elaborated on that theme in his sentencing comments. And this is Judge Newman talking again, I don't question at all the decision of the state not to pursue the death penalty, but as I sit here in this courtroom and look around the many portraits of judges and other court officials and reflect on the fact that over the past century, your family, including you, have been prosecuting people here in this courtroom, and many have received the death penalty probably for lesser conduct. I'll go ahead and make that a little bit bigger so y'all can read that while I'm talking. What Mr. Murdaugh's grandfather or great-grandfather did in a courtroom before Mr. Murdaugh was born has no relevance to any issue in sentencing, which is certainly true. I think Judge Newman would acknowledge that that wasn't relevant in the sense that he is being blamed for that. What Murdaugh's team is saying is it shouldn't have been mentioned at all. The fact that you mentioned this suggests that you had a bias, and it was a bias based not on facts that you heard and your application of the law to those facts. This is like a true personal bias against Alex Murdaugh. It's a bias against his family. You took it way further than was permissible under the law. And now, of course, they took this opportunity, the Murdaugh team, to argue against what they believed was unfair allegations that they had unfairly attacked law enforcement. They said, Mr. Murdaugh's lawyers worked many hours, and this shows you that that's at a personal level to them. Mr. Murdaugh's lawyers worked many hours, not just Murdaugh. Murdaugh's lawyers worked many hours after midnight and on holidays to prove the state fabricated evidence that Mr. Murdaugh's t-shirt was stained with human blood in a pattern unique to gunshots. The state conceded the point and did not attempt to introduce the fabricated evidence. And they did win that point. The Murdaugh team did win that point. The state's expert admitted GPS data on Maggie Murdaugh's phone for the night of the murders, which would have conclusively proven whether Mr. Murdaugh ever had possession of her phone after her murder, was overwritten and lost because it was left powered on for a week in SLED's forensic laboratory while not secured in a Faraday bag or box. There are many other examples that Judge Newman would state on the record that these efforts were objectionable maligning of law enforcement rather than defense attorneys doing their job is evidence of personal bias. So it's in statements like that right there, what we just read, that you can see that the animosity that's crept in includes between the lawyers and the judge. It's not just related to Murdaugh, it's also between the lawyers and the judge. And the statement, and the lawyers are taking offense, saying, we only argued this and we won on these 2 points, and we only argued them because that's our job. You can't suggest that we are maligning law enforcement. That's an unfair allegation against us as attorneys. And we'll keep reading. Judge Newman's, I'll make it a little bit bigger for y'all to be able to see. Okay. Sorry, I'm working with like multiple screens here. Judge Newman's extrajudicial statements after Mr. Murdaugh's trial violated Canon 3 of the Code of Judicial Conduct. And this is important because we are now moving from the area of statements made at trial to statements made outside of the trial. This is very important. And the last argument plus all of these, they're going to say show bias against Murdaugh generally. The reason why that matters is some of the statements that were made that are argued in this, I am going back and forth between way too many screens here. Okay. Some of the things they argue would only get Judge Newman off the case for the murder trial. For example, statements that he made being a witness in the Becky Hill matter. That's only going to take him off being a judge in the murder trial. Now they're expanding that. They're saying this is more than that this is something that shows bias against him in general, and therefore they're going to argue he ought to be off all the cases, the financial crimes cases, the motion for new trial. He ought to be off everything because this is something that it covers everything. This is his overall bias against them. And these statements, they're going to argue, say the same thing as well as relate specifically to the case. Okay, I'll make it a little bit bigger, having said that to you. Judge Newman's extrajudicial statements after Mr. Murdaugh's trial, I already read that. A judge shall not, while a proceeding is pending or impending in any court, make any public comment that might reasonably be expected to affect its outcome or impair its fairness, or make any non-public comment that might substantially interfere with a fair trial or hearing. And I'll keep reading. The requirement that judges abstain from public comment regarding a pending or impending proceeding continues during any appellate process and until final disposition. Judge Newman nonetheless gave public interviews. It is almost unheard of for a judge to give interviews about a pending case, even cases in other jurisdictions. When it does occur, it is almost universally found to be misconduct. This is probably going to be their strongest argument with the appellate court because it is unusual. They're going to comment later about why they think it happened. We'll read that in just a minute. But it is unusual for a judge to make a comment on a case that's pending. It was the same problem with Becky Hill publishing her book about the case while the case is still on appeal because it could come back. And if the appellate court reverses, there will be a new trial right there in the Colleton County Courthouse unless there's a change of venue. And that was exactly what the problem was. Becky Hill was writing about this, making comments about it, suggesting her opinion and also other things that the Murdaugh team complains about. And she was doing that before the appeal was even lodged, much less before it had been finally resolved. And so that was one of the things they argued about. And they're saying the same problem happened with Judge Newman. He went out and gave these interviews, and you can't do that as a judge if there's a pending case. We'll keep reading. And I'll make it a little bigger for you. Judge Newman expressed his personal opinions regarding Mr. Murdaugh's guilt. In my mind, no doubt he loved his family. I don't believe that he hated his wife. And certainly I do not believe that he did not love his son, but he committed an unforgivable, unimaginable crime. And there's no way that he'll be able to sleep peacefully. So you can certainly see where, based on that, the Murdaugh team would feel like if it came back for a new trial, Judge Newman could not fairly try the case because he personally believes that Alex Murdaugh actually murdered his wife and son. So if it came back for a new trial and the question was once again, did Alex Murdaugh murder his wife and son? Judge Newman has expressed an opinion that he believes they did. And so that's the Murdaugh team argument. Judge Newman also commented on choices made by defense counsel, commenting that the defense requested site visit was more helpful to the prosecution than the defense. In other words, defense really requested that everybody go to Moselle. That ended up backfiring, many people thought, and the jury used that to answer some questions, fill in some blanks, and conclude that Alex Murdaugh did commit the murders, as opposed to what the defense team thought, which was they would realize how far the house was from where the murders occurred, and that because of that huge distance, they would understand the argument that Alex Murdaugh wanted to tell them, which was he didn't hear the gunshots, things like that. So but the defense team, again, saying, look, there's a choice made here by defense counsel, and Judge Newman is criticizing it. Defense counsel opened the door to many other things by the manner in which they presented the evidence. That's Judge Newman talking about the defense counsel having opened up the door to the financial crimes and maybe to other things as well because of how they presented the evidence. So we'll keep reading. Now they're going to talk about what Judge Newman said in interviews and in speaking about the decision to admit the financial crimes. And here's what he said. It was a pretty controversial decision. And as will be the subject of an appeal, and no case is final until there's a final ruling on the appellate issues. So I think the record speaks for itself. Initially, the ruling was going to be limited to things occurring within the res gestae of the moment of the day of the murders. And the lawyers I ruled opened the door to many other things by the manner in which they presented the evidence. Then, of course, once the defendant takes a stand and testifies, then almost everything is fair game at that point. So the res gestae that he's talking about related to the moment when the murders occurred. And so he's saying, having taught, it doesn't even really matter what the legal argument is. Essentially what he's saying, though, is they opened the door. The defense started asking about things related to the crime. And once they did, then the state was allowed to put in more evidence. And so they opened the door by doing that. We'll keep reading. And then the defense says, well, wait a minute, because we don't think we opened the door, and they decide, let's go ahead and argue this. We know they're going to argue it on appeal. So here's a little preview of what they're going to say on appeal about why the financial crimes should not have come in. The questions that the defense asked of witnesses were things like, and how would you describe Paul's relationship with his father? Paul was the murdered son. And would you tell the jury what you observed of Alex's relationship with Maggie? And Judge Newman ruled those questions solicited character evidence that opened the door to allowing the state to present weeks of testimony about unrelated financial crimes. That's interesting. It gives us a little preview into what they're going to argue. That's a very, very broad ruling by the judge. If all of that financial evidence came in just because of the relationship between Paul and his father, Maggie and Alec, that is definitely an argument. And so that's what the defense is saying. This is our appellate argument. This is what we're going to be arguing. Let me take a quick moment to look over here in the chat. Okay, good. I'm just making sure, am I missing anything? We're going to do a few questions at the end. So if you have some questions, be sure to put question marks at the beginning. That gives me a better shot of finding it as I look through real quickly. And I'll give you some info at the very end. I'll give you a little warning, but this is sort of the advance notice. So you might be thinking about what you're going to ask when we get to it. What the next thing they're going to argue, in the reading on through the motion, in other words, the petition, whether Judge Newman's ruling constitutes error is an issue for the Court of Appeals based upon the trial record. And they say Judge Newman loses the appearance of impartiality. Keep reading. It is categorically inappropriate for a judge to give interviews about a case pending before him, which includes a case on direct appeal that may, as here, appear before him again for further judgment. This is a very, very strong argument. It is true that it is generally considered inappropriate for judges to comment on cases pending before them, and judges don't do that. They just don't do it. Here's what it says next. A judge never may discuss the merits of a pending case in a non-judicial forum, especially when he has reason to know that the parties to the litigation may appear before him again for further judgment in the case, will almost always give rise to a legitimate claim for disqualification. Now, they're quoting a case not binding on the court where they filed this. It's from the DC Circuit, but they're saying this is how other courts feel about this, that this is very serious for a judge to discuss the merits of a pending case. This is where I think they give a little bit of an insight into why they think Judge Newman did that. Judge Newman had good reason to believe his role in the murder trial was complete with the conclusion of the trial. Judge Newman is retiring at the end of the year. He knew the direct appeal would not even be briefed before he left the office. In March and July, when he gave interviews, no one expected the suspension of the appeal for a trial court evidentiary proceeding only a few months after the verdict. But as Thurgood Marshall often said, rules is rules. So that's really important, because what they're saying is that the statements that were made by Judge Newman, he never thought he was going to hear this case again. It didn't occur to him that this is going to come back. Appeals take sometimes years. They definitely take more than 8 months, which is about probably 8 months from the time the trial ended until the end of the year when he retired. There was no possibility it would come back. So they're speculating, well, probably the judge felt like it wouldn't be a problem for him to make these statements or to go out and do interviews. What would be the harm? Because he's never going to touch this case again. And yet, surprise, surprise, here the case is in front of Judge Newman again. And so the defense is saying, now that we have the case in front of him again, that's not fair, because he did, in fact, go out and make those statements. So that is probably their strongest argument. We'll keep reading. Judge Newman is required to disqualify himself from hearing Mr. Murdaugh's motion for a new trial. And I circled this part, disqualify himself or herself. So the reason why I think that is so important is here is a weak link in their argument, which is they really, the judges on the Supreme Court may well say the same thing that the Brooks-Houck appellate court said, which is, you want that? You need to go to the trial judge first. You need to get a ruling there. We don't want to just come in and tell him what he ought to do. Let the judge make the decision first, and then we can look at it later. Alex Murdaugh knows that that's a weak link, and so you're going to see their argument about why that's not enough. So, and they point out here in number 2, sorry, probably broke some ears there, that it's a due process issue. This is like important, they're saying. So the Murdaugh team realizes they have a problem here. They have a problem because the appellate court isn't going to want to make a ruling and force the judge off. They aren't going to want to force Judge Newman off the case. If it causes him to lose face, it could be embarrassing for him. Why would they do that? They want him to make that decision. That's a natural thing. So here's what the Murdaugh team is arguing against it. They're saying we have no effective legal remedy. We have no real way to get this unless you do something, unless you, Supreme Court of South Carolina, do something, because we really don't have any way to meaningfully review it afterwards for bias on appeal. The dispositive factual findings will be based on weighing the relative credibility of witnesses. So what they're saying is if what happens is, as I mentioned a little bit earlier, if what happens is that the judge interviews privately or even in front of people, but gets to ask all the questions of these jurors, if he then makes the findings. I believed this witness and I didn't believe this witness. Then when we go up on appeal, you're going to accept all his findings. If he says, I don't believe the Ed juror 785, I do believe the other jurors, and this giving you a little preview of what's going to happen on Monday when we talk about the state's motion. So I believe these and I don't believe this juror. Then what do we do about that? We're not going to have any real effective way to do that, because the appellate court is going to just accept whatever it is that the trial court has found. And so we need you to rule right now. It's impossible to show that a judge's credibility determination stems from extrajudicial sources. That's so complicated. I think I pretty much explained it already. Sorry, that's so complicated. I think it would be hard to understand. Only this court has authority to determine whether a judge has violated the Code of Judicial Conduct. And then they throw in this additional point at the end. Mr. Murdaugh recognizes that Judge Newman is a distinguished and honorable jurist of outstanding character. Mr. Murdaugh simply argues Judge Newman has violated certain rules. And they want him off. Remember, not just the motion for new trial. They don't want him presiding over future trials of indictments against Murdaugh. It's much broader than that. So they want Judge Newman off entirely. Now, I told you I was going to talk just for a minute about why this motion is nuclear and why it is. And you can probably figure it out. If you make a motion like this as an attorney, what do you think is going to happen if you lose? You already believe that the judge is biased against you. Is he going to be less biased? Is he going to be more favorably inclined to rule for you? No, not at all. And judges have a lot of discretion. They really do. And so if the judge is angered, whatever you saw before in terms of bias will be greater. It's every ruling where there's discretion, you can worry that the discretion will go against you as opposed to in favor of you. That's why this is a nuclear motion. You do not use this unless you really feel like there is nothing else you can do. And I want you to think too about from the attorney's perspective, because for Murdaugh, this is sort of a one-time thing. I mean, he gets one life. He's going to spend it in jail, and that's going to be true whether it's the financial crimes or whether it's the murder. It really, in the end, doesn't make a difference. But for the attorneys, this is nuclear war, and they're going to be in these courts again. They're going to be appearing before these same judges. They're going to be they're going to be filing cases in these same courts. So it has to be done very, very selectively. If it's used regularly or often, that's crazy. There's just no reason for anyone to do that. I will say, I don't think I have ever filed one of them. If I've been on a team where we filed one, I am sure I opposed it because I just cannot imagine the circumstances. In this case, it shows you that the Murdaugh team believes they are at the extreme end, that there is no hope that he will ever rule with them on the motion for new trial, on anything. They have to believe that or they wouldn't file this. That's how nuclear it is. And that's why I gave the video the title it did. So what happens next? Well, we have a bunch of things that we need to know. First of all, will the Supreme Court even make this choice, or are they going to say that Judge Newman needs to make this choice? Will the Supreme Court say what the House Court said, which was, we're not going to decide that. You need to take it to the trial court first. What will the state say? We are going to find out what they say to the motion for new trial on Monday when we cover that. And what is Judge Newman going to do in the meantime? Will he rule on this? Will he have anything to say about that? Of great interest. And remember, they're asking for him to recuse himself before their trial. Their trial is coming up at the end of November related to one of the financial crimes. So there's just a matter of maybe 2 weeks that he would need to recuse himself, or he's going to try that case and just move forward with it. So, okay, I am now going to be looking for questions. I am going to be I'm going to be checking these questions. And I did see one a while back where somebody put in some question marks, so I don't want to miss that. Annie K was asking me, as related to other Murdaugh trials, where Judge Newman is presiding over several, aren't they unrelated since Alec has already pled guilty in those? You are right that he's pled guilty to those crimes, but he pled guilty in federal court. He said he wanted to plead guilty, strike a deal, do something with the ones in the state court, but at the last hearing, he said the state is refusing to accept that and wants to go forward with an actual trial. So he can get up there and admit what he did, but there's still going to be a trial. And so that's why the November setting for the trial. I assume he won't testify, but if he did testify, he would just admit that he did it and I guess ask for mercy, which the Murdaugh team is convinced he will never get in the sentencing. And that's why they are so intent on getting him removed from the case. Okay. All right. That was Annie's question. Let me zip down to the bottom. I am not seeing questions. Wait, what? I don't believe that. You folks always have questions. Y'all always have questions for me. So I am looking for them. Oh, here we go. Rolled away the stone. Do you think Griffin and Harpootlian are using the free press for future clients? And say, see, we went to the ends of the earth for Alex Murdaugh. Well, I did notice that on Dick Harpootlian's website, they actually on the front page talk about his defense of Alex Murdaugh. So are they using this to point to? Sure, I would think that certainly has to be something they want to do, but I also don't see anything wrong with that. I think that would legitimately be something that if I were hiring a defense attorney, I would want to know that this is somebody who will really work for me, who would do whatever it took to get me a fair trial. So I think that's a legitimate thing, but do I think that they would like that to be the result? Probably. I think that would make sense. AJ Lowe is asking me, I think Alec is trying to get this verdict overturned because that means he will go to federal prison instead. I have speculated about that too. I've wondered about whether since he's pled guilty in federal court, if he gets this overturned, does that mean they move him to federal court and he serves a sentence there and then only then gets transferred over to state court? That's what's happening for Corey Fleming, who was tried alongside Alec, or would have been tried alongside Alec had he not pled guilty. So that it could be that there will be that result, but I don't know. I don't know whether that would actually be how it would work out, but certainly that's something that I think a lot of people are thinking is he would rather. So for those who don't know, federal prison is considered to be nicer than state prison. State prisons are a little less funded, just considered to be not as nice. And Alex Murdaugh may be thinking that he would have a better shot at a nice life in a federal prison than a state prison. So that's what AJ Lowe is asking me about. So She Jukester is convinced that Alex Murdaugh murdered his family, and I understand that. And so was the judge. The judge agrees with you. The judge believes that as well. So let's see. There were some question marks. I'm looking for those question marks. Oh, Janet. Oh, thank you, Janet. Janet thanks me for my very fair breakdown of all cases. That is something that I aim for. I always get really amused when I look through the comments usually after a live and later comments, and somebody will say, you are clearly for the defense, and just a few above that, you are clearly for the prosecution. Like, all right, that's good. That's what I'm aiming for. If I can make their arguments best possible so you can understand them, that's the goal. That way I made an argument and you can make a choice for yourself, because I really feel like the people who watch this channel and subscribe to this channel, you're intelligent enough to think through this for yourself, and you want to actually understand it so you can think and make your own choices and decisions. Okay, let's keep looking for. So Hedgehog in Space, how much of this drama goes on in other bars, just less public, or is South Carolina an anomaly? Oh, definitely not. But one difference is that the South Carolina bar is a little bit smaller. So for example, a bar in a state with a lot more people is going to be bigger. People aren't going to know each other as well. But when you get down to the local level, you'll definitely have those sorts of things happening. Or in a smaller state, it will definitely happen. There's always drama like that, and people who just don't get along, a judge doesn't get along with the lawyer, or vice versa. Definitely happens. And I want to thank Annie. Oh, thank you, Annie. I appreciate that. And let's see, Mitt Spunky said, to Mama Pinks, Marlon, Harvard Lawyer Lee in the chat. Thank you. We appreciate that, Mitt Spunky. And I will say, great time to say thank you to the moderators, Mama Pinks and Marlon. I really appreciate the work you do each and every live, which, speaking of, are every Monday, Wednesday, and Friday at 7 p.m. We go live at 7 p.m. Eastern, and we talk about all the cases that you're talking about. We definitely will be getting back to Delphi, but on Monday, we are going to cover that brand new motion, brand new response to the motion for new trial filed by the defense. So we are going to be looking at that in detail. There are sort of affidavit statements from the jurors. So we'll look at that. Some of them are nearly illegible, but there were quotes of it from inside the brief. And we will be looking at that and talking about that. YT3 says, what do you think about the 12 jurors coming forward to support Becky Hill? Well, it wasn't all 12, but we will talk about that on Monday, YT3. That's going to be very important. Zane Price, why did Newman call the omission of financial evidence initially race gesti to the days surrounding the murder? That's kind of a little technical, but he was talking about the fact that the state's motive, they believe, is the reason that he committed the murders was all of this financial pressure that was mounting on him right about the time of the murder. So that's what they're talking about in that time frame right around the murders. Okay, one last question, if there's one. Are we going back to Rex, the Gilgo killer case? We are definitely doing that one as well. I don't know if you saw that there's going to be a press conference / symposium by John Ray, and I'll be interested to see what he has to say about that. So we will definitely be covering that as well. So, all right, everybody, thank you. Please be sure to subscribe. You don't want to miss on Monday. And if you would like the video on your way out, I'd really appreciate it. It'll help to get out to more people and have a